5 seconds to go. Start. This appeal is at the instance of the state of Gujarat and is directed against the order passed by the High Court of Gujarat dated 6th May 2021 in revision criminal miscellaneous application number 3819 of 2021, by which the High Court ordered release of the respondent accused herein on bail in connection with the first information report being CR number of 2020 registered with the DCB Police Station, Surat City, District Surat, for the offences punishable under sections 311 and 2, 32 and 34 respectively of the Gujarat Control of Terrorism and Organised Crime Act 2015, for short, the 2015 Act. The question that falls for our consideration is whether the requirement of continuing unlawful activity as defined under section 21C of the 2015 Act necessarily requires a separate FIR to have been registered against any purported member of a gang after the promulgation of the 2015 Act, that is, after 1st December 2019. To put it in other words, whether an FIR under the 2015 Act special enactment is maintainable in law or can be registered if there is no FIR registered against the accused after the promulgation of the 2015 Act for any offence under the IPC or any other statute. The aforesaid question arises especially in view of the fact that the last offence registered against the respondent accused is of 2019 and the charge sheet in regard to the said FIR was filed on 21st January 2019, that is, indisputably prior to the promulgation of the 2015 Act. Furthermore, there is no FIR registered against the respondent accused after the 2015 Act came into force with effect from 1st December 2019. On 27th November 2020, an FIR came to be registered against the respondent accused herein and 13 other co-accused for the offence punishable under sections 311 and 2, 32 and 34 respectively of the 2015 Act. The respondent accused came to be arrested on the very same day and date of registration of the FIR, that is 27th November 2020. The respondent accused applied for bail before the Sessions Court at Surat by filing the criminal miscellaneous application number 6483 of 2020. The Sessions Court at Surat rejected the bail application vide order dated 21st January 2021. The respondent accused thereafter preferred bail application before the High Court by way of the miscellaneous criminal application number 3819 of 2021. The High Court allowed the bail application and ordered release of the respondent accused on bail subject to certain terms and conditions. The High Court granted bail to the respondent accused, essentially relying on the dictum as laid by this court in the case of State of Maharashtra versus Shiva alias Shivaji, reported in 2015-14 SCC 272. The High Court took notice of the fact that the 2015 Act came into force with effect from 1st December 2019 in the state of Gujarat and no FIR had been registered against the respondent accused for any substantive offence after 1st December 2019. In such circumstances referred to above, the High Court took the view, relying on the decision of this court in the case of Shiva alias Shivaji, Supra, that the 5 FIRs which were registered in the past for different offences under the Indian Penal Code cannot be construed as a continuing unlawful activity of the respondent accused so as to prosecute him under the provisions of the 2015 Act. We must look into the relevant observations of the High Court made in its impugned order as under. In order to curb and control organized crime and terrorist activities in the state of Gujarat, the legislature has promulgated the Gujarat Control of Terrorism and Organized Crime Act 2015 wide notification. The act has come into force from 1st December 2019. Sections 2C and F, which define continuing unlawful activity and organized crime syndicate, read as under. Continuing unlawful activity means an activity prohibited by law for the time being in force, which is a cognizable offence punishable with imprisonment for a term of 3 years or more, undertaken either singly or jointly as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years, and that court has taken cognizance of such offence. Organized crime syndicate means a group of two or more persons who, acting either singly or collectively as a syndicate or gang, indulging in activities of organized crime. Stop.